I do want to see if we can get to just at least one question, thoughts from both of you on this. And I want to talk about the future of FWW methodology. I just want to see if we can tap on that a little bit. And Jonathan, do you want to start with that?
Sure. Well, I think that particularly at a time when we have work which is not all in the same physical place as it may have been pre-pandemic, and we have the emergence of a gig economy, which, while centered on independent contractors, also involves a variety of other aspects that.
Oh, did we lose Jonathan?
I think we may have.
Oh, we might have lost Jonathan. Ed, do you want to go ahead and pick up?
Well, I will try to do so. So I think where he was going, certainly there's going to be a lot of classification issues whenever you're dealing with contractors. And, it's one of those common pitfalls that we've been talking about where people say, well, I've got these 1099 employees, and I always cringe. They're either contractors or they're employees. They're not both. And do they meet the Department of Labor standards for being an independent contractor? Do they exercise independence in determining their work methodologies, when they work, how fast they work? Do they work for multiple entities? Those are going to be common pitfalls. And I think that's a primary situation that you've got to address in any kind of gig economy where you've got people who are challenging the way in which we have traditionally performed work. I think that the fluctuating work week standards that Jonathan was talking about, are largely going to be based upon facts and there's Jonathan again.
Sorry, everyone.
Go ahead. So why don't you pick up where you left off?
I have no idea other than to figure out which of my feet was in my mouth. Please go ahead, Ed.
Well, I was just saying that, I think in these cases, it's largely fact-based. What was the agreement? You've got to focus on that. And the agreement is going to be all the difference between summary judgment and going to trial. And if you represent employers, you want a summary judgment. You don't want to be going to trial on these cases if you can avoid it. I mean, sometimes we have to, but summary judgment means everything. And so that agreement up front is well worth its weight.
The other point I would simply make about the agreement up front is more a human resources point than an FLSA point. It's when you've done that, when you've created a document and in your orientation package, you've gone over with the folks who are going to be receiving overtime under the fluctuating work week methodology, it's clear, and you head off, I think, a whole bunch of issues that you might otherwise have. I don't know, Ed and I haven't really spoken about this in any detail, but I think both of us have learned in our careers that clarity at the outset, understanding of the way in which people are going to be treated and treating similarly situated people similarly are just keys to effective human resource management.
Absolutely. We always want to be proactive in our workplace expectations, setting forth what the employees are going to get from us, and that is central. Transparency is key.